Tonight's Power Hour is sponsored by Innovative Potential. Hi everyone. Tonight on the Power Hour, we're going to be talking about patents, patenting, the patenting process, and sort of what I've encountered by learning, and how that's going to help you out, or rather, how it can be used. It's a complicated process. It's not really well encountered, but everybody kind of like the general consensus, like of it is that it's important for protection, and it offers protection for your idea. It grows into a business. It's a tool, a legal tool that is able to basically it gives you the security and the peace of mind to attract investors for a limited amount of time. And how that goes, we're going to walk you through it tonight, and just sort of put my just experiences and talk. It's not a terrible process, but it's one of those ones where you're getting into getting into a business that you are approaching a requirement for patenting. Plan for a long haul. I really kind of don't know how to say this otherwise, but I built the asset management wheel. To be able to, I'm just going to find it and bring it up. Just a brief second here. I didn't think I was going to talk about that, but it was brought up. So anyway, the asset creation wheel here. There we go. The wheel of asset creation was help guide me through the actual patenting process, and pull that up. Okay, so this wheel of asset creation is linked to patenting process in the sense that is that going over? There we go. Okay, that's better. In the sense that this is, you can basically work yourself, partners, your community, and public to be able to complete like growing a business with a patent involved. So basically, how this kind of goes is you start at a need for something. Yeah. You write out parts of your patent, and there is an anatomy of the patent. There are sections in the patent document that all patents sort of adhere to, and here I'm gonna pull one out. If you're doing it right, it is a large document, because it's a document that says you've done your homework. And it's a document that, when it expires, it's going to help other people enter the market. And it's a public disclosure, because if you don't disclose anything, nobody knows it exists, or it works, or how it works, or why it is. And you're supposed to be doing it for the greater good. It's a very idealized system. And that's part of why the public section in the wheel of asset management is its own thing. I'm not going to walk through the asset creation. There's another file. There's another picture that was up earlier that I want to walk through, because it explains more of how long of a time frame you can actually be looking at. And it's not to say that going to be like super expensive, but but it is a chunk of change. It should be taken as seriously as your business. So people often kind of show up all really excited, and it's like, oh, they got for a solution in the wheel part there, in the navy blue ideas for solutions. All them working, they're gonna, they start investigating what a patent is and how it works, and you go on and you see like their patent subreddit, and when you read some of the initial questions, they're like, oh, everybody got this idea at work, but we want to start doing this, and it's always the same initial questions. And those initial questions are really just basically like the people asking the Reddit, should I even be doing this? But they're asking it without trying to disclose anything. And it's kind of like, it's always the same kind of information just recirculating over and over again. Where it's like, yes, you should get a lawyer, you should get all these things. You should go, balls to the walls, all 9 yards kind of stuff. But nobody actually sits down and plans it with you. And then the next set of questions that you find on the Reddit are, well, how much is this going to cost? Where do I get the money? Does anybody know anything where we can get money for patenting? Like, well, it's not really it's not a rich man's game, but it is a game but it is an area that requires a lot of foresight to get what you want out of it. So I'm going to switch over to the other one to show you, because it can be it can be a process that can last up to 2 to 3 years long. So you do have to plan a lot for this to. There it is. There's a picture. You have to plan a lot for this to be. Really be effective. So basically, up in the top corner, where is there? Fix the camera a little bit. Up in the top corner, there's the invention idea. So you get your invention, and then what? Typically, when you hire the lawyer and the law firms are there to protect you from making too much of a disclosure. What they're gonna brief you on initially. Actually, no, I jumped ahead. I'm sorry. I jumped ahead here. We're going to go back to the tool here, because this is basically, where is it? There it is. Okay. Basically how this works is when you want to patent something, you've kind of completed most of the need for something, the memes, idea for solution, and now you're kind of like, when you realize and you're kind of flirting with the disaster of a patent, research phase here. And what you're doing is you're looking for a plan of actions. Like, are you actually going to be able to commit to the financial obligation, not only of the company that you're to build the company and the patent with, but you're also looking for other resources. So basically, you do have. From my own experience, I had to go through this wheel about 3 or 4 times just mentally to be able to find the resources online that were available at my state or provincial level that would help me actually achieve a patent. I'm still in the patenting process because of its nature. That is just what it is. You're in for the long haul. But I went an extra time because this is my first endeavor, and I got all the help that I needed, and I wanted to make sure that basically I want to make sure I didn't fuck up. And to the most extent, there haven't really been issues regarding that. So why I'm on this asset creation wheel right now is those government programs in black at the bottom. That's where you can't, that is a huge untapped resource, particularly for entrepreneurship type of grants. And I kind of touched on this in the asset creation talk, but this is where you can get You might not get money for the patent itself, but you might be able to get money to talk to the lawyers, to initiate some of the conversations that are required to actually build and protect your business. So what we're kind of talking about here is these were two programs that were canceled by the Ontario government quite recently, before COVID even, because of their success. These funds get exhausted, so it is a first come first serve. Unfortunately, they've been canceled at this point, but basically they allowed up to $1,500 to speak or provide an expert consultation with whomever. They're general categories, but I use them for a patent. So we applied and we got they're like a microloan grant, and that covered our initial conversation and our non-disclosure agreements, our initial applications with the lawyers to give because the lawyers are coming in blind on this too, and you're building a partnership with the lawyers at the same time. The patenting professionals. We're not going to call them lawyers. They're patenting professionals. They do practice law. They are lawyers, but you have to approach them not as that courtroom, that courtroom drama kind of thing. They help you build that situation. They help you to build that situation into a victory should it ever come to that. And that's sort of what this whole patenting process is making sure that you're going to be able to sort of win a court case if and when and how it should come up to that. And that's really what it's all about. But those government programs, you have to look at them at your own local individual level, because different regions may or may not have them, or they might be called something else. They might not be called they might not be labeled patenting. They might be labeled innovation grant, and you can use it towards intellectual property. It won't even be called patenting. It'll be called intellectual property. But that incorporates trademarks and patenting and other types of identification registers that are really there to just ensure that what you're creating is yours. Videos like this is video proof. This goes into more of a legal framework kind of thing, and it's a little bit older because it's an older system, but the assurance of the patent has a legal ramification of it tied with it that allows you to control what you've patented in the nation that you're patenting in. So you can patent in multiple places. I'm going to get to that in a little bit, but I really want to stress this government program a little bit more, because what I had done is I did a $1,500 grant, and then there was a $5,000 grant to get the documentation written up, the documentation and the pictures published up. And it wasn't a small document. Just the written section alone in this one is 26 pages double. It's no pictures, and you really do have to explain what your invention is and what it's about. So all of that money goes to create the filing, and I'm going to switch over now to the other picture, because that's where it sort of picks up the process more aptly. And it's over there, and it's over there. Okay, it's here. You have your invention in the top left hand, in the top left hand corner of the screen. So you got your invention, So basically, we're going to be focusing on the bottom part here, this bottom timeline kind of thing. It's registering in months. So you have 0 to 30 months of how much time there is before you got to pick a country. So basically what this the way this goes is, okay, you show up to the lawyer, you talk to the lawyer, you get that process starting. They're writing out you go through their non-disclosures, you sign some non-disclosures, you sign some initial forms, and then you have to tell the lawyer about your invention. So this is really quite important in the sense that your lawyer's your patent expert is the first person you're actually opening up to about your device. And it's not in their interest to sort of shaft you and see it. They have seen enough of you, because every time somebody comes up with their first patent kind of thing, they've seen enough. They sort of it's their bread and butter demographic. Congratulations, they're the first one. You're not special in the sense that this is your first patent. So they do kind of just sort of they do kind of kill. They do put a damper on the electricity that you're feeling, but at the same time, that's the first sort of breath of fresh air you as an inventor kind of get in knowing that this conversation is actually protected. So your own mental health is sort of insured with speaking with a patenting expert lawyer kind of thing. So basically how the patents work is you make your document, right? So you got your document and you make all your pictures and you put all your stuff in and it's almost a how-to guide, how to build your thing, how to build your invention, because there's sort of three parts to this. There's the preamble, there's the back, there's the description of invention, what it is, what it's used for, kind of keep it short and brief. But then there's the background of where and how your invention work, the summary of invention, and your description of your drawings, because that it still has to be said. And then there's a detailed description. So once you kind of get all past that, then there's the claims section. And the claims section is the part that's going to drive you fucking insane. It's more of it's the part that's not intuitive. Everything works great until the claims section. And the claims section is basically the claims section is the part of your invention that is actually the invention, the part that is making it unique, the part that is making it stand out, the part that is saying, of all the other people in the world ever, this thing is different and unique and special because of these claims. And they basically function as, so here's somebody else's examples. Here's somebody's approved example. They're kind of a thorn in my side. They're a thorn in my side because it's a reference that's being used against my patent. So that sort of the patenting process, nobody really. It's not that these people have created my creation, but their claims and how I am describing my invention, they have become very hard to delineate. And if they can't be delineated from each other, then in a court case, because you're always building the court case up, it's like someone's going to look at the claims section and say, basically, I can't tell the difference by reading this document, what's the difference between the prosecutor and the defendants? Were the patents, and it's not in the interest of the government to issue duplicate patents. It's in the government's interest to retain everybody's individuality in this instance. So they are actually working really hard to maintain that division of this is these people, we are backing them up as a nation, versus these are these people and we are also backing them up as a nation. We just want to make sure that these two people are to independently win their own court cases, kind of thing. And that's sort of that's the part that's going to eat time. And there's kind of no way you can really you can't really fight that. But you have to change your claims to still be able to cover stuff. So that being said, the claims section is really much that if I have a patent that says I have A, B, C, and D on it, and somebody else has a patent that says that they have A, B, and E on it, the fact that I include D in my patent differentiates our stuff. So it's like we can still get it. It's just we have to speak better English, more or less. But that's kind of that leads me into this bottom section here. So what you have is, okay, you prepare your document. It says everything you want to say. Congratulations. And then the lawyer sends it off to the lawyer will then register it with a patent office, and then you get a priority date. And what the priority date says is that in terms of this patent document, this is the first time it's ever been reported ever. Boom. And like this magic sparkle happens, and it's now public. It's now patent in waiting, kind of thing. It's like this is when, once you file this application and you get your priority date, now you can claim patent pending. Okay, and it's like, oh, and that's what when you see Dragon's Den and you see Shark Tank and you see whatever the English one is. All those entrepreneurial TV shows, like when they have patent pending on it, that's what it is. The person has submitted, or the company has submitted to the patent office, but they haven't cleared all the checks and balances yet. And that's fine. You get legal rights to defend your patent at that point, but you can't go after somebody else. And that's sort of the big thing. So if somebody else is doing this in the meantime, during your patent pending phase, they're going to be able to make money. And then if you get your patent, you can then go after them and collect royalties off of them from your priority date. So you're never really losing, but it's a retroactive against the other person rather than a proactive, which isn't terrible. But anyway, that's more of intellectual property strategy. So anyway, what I did, I went the PCT route. You can do two things. You can go directly into national filing, patent pending. So your patent pending is sort of like the way this system is structured and set up is basically you get your idea, your light bulb goes off, and then you create your patent application. You take your patent application and you put it in the patent office, and then you kind of have a year to decide if you want to let it live or die. So in this initial year, you have the opportunity to make sure that it is actually an invention. So what you're actually doing is you're earmarking something ahead of time, and before you get like a legal proof of invention. Um, so you earmark it ahead of time, and then you have like a year to be able to just, okay, I now have a year to do additional research on the subject matter and prove to myself and to other people that yes, it is worthwhile to go forward and continue with the process. A lot of stuff gets thrown out here because a lot of ideas, it's like, oh, a lot of times people just sort of like, it's cheap to file. It's like $500 to file if you do it independently. A lot of times people just file. It's not even like 500, like 250 or something. Go anyway. A lot of times people just throw it out there, and then if nothing sticks again, and if they find something, then they drop it. Unfortunately, it counts as a publication, so if you abandon it, then you're never going to get the patent for that. You can repick it. There's some process stuff, but let's say you're going ahead with it. So now there's two options. So you can either go, it's called the Paris route, where you go directly into the nation that you want to, and a national filing is something. So you file your patent application, and you're in patent pending status for a year. You can file sooner, but you have a year's worth of time to either go Paris or patent cooperation treaty. One is they call it the Paris route because the idea here is you're just applying in your nation. You just go directly to apply to your nation. The patent cooperation treaty is more for an international. If you're going to go after multiple national filing entries, there is an international office. It doesn't really count for anything, but it still counts as a sense that no, it's an evidence in support or not of in support of your country, because each country is independent of each other. So Canada and the United States and Mexico, you can get three different you can get three of the same patents in each of those countries, or because of the volume in the United States, you might be able to patent in Mexico and Canada, but not in the United States because someone filed in the United States first. It doesn't mean you're necessarily out of business, but it does mean that you might have to get it protected by a different nation. So there's a lot of research and a lot of homework to be done in that year to make sure that you're going to be able to make it through to the end of the finish line. So that's why I went with the PCT review, because basically what's happening, and that's that international phase section that we're talking about from 12 to 30 months. So in the first 12 months of your patent, and this is all patent pending. You then have a year to file with the international organization, and then they do some stuff, but the international organization is looking on your behalf and your application's behalf, and they write you a recommendation whether or not this is going to be whatever, or how is this going to play out if you have multiple different national requirements. And it gives you an idea of the lay of the land of how your document is going to behave in different court systems that may or may not have patents approximating your own, pre-existing, or that come up after the fact, because it's always just sort of like, well, here's this person's idea, I'm going to write something and make my own thing, I'm going to make my own car, but I'm going to add, shocks to the wheels this time, or I'm going to put airbags in the car, or I'm going to make an electric car. You kind of get all these little extra widgets on top of your base 4-wheel cart structure kind of thing. So the international phase for the PCT lasts for an additional year and a half. It's an additional 18 months with on top of the 12. So if you really want to buy time, you can actually buy you can buy almost 2 years worth of time. It's not a real extra cost to go the PCT route. And that's it. It's just not that much more expensive. It buys you time before you enter the national phase, and it's not discounted time either. It's just like you can get if I have to remember this correctly, you can use the international examiner's inputs in the national phase. So when you go into the national phase, the work that you just did in the PCT stuff, in the international stuff, goes with you and it counts. So it gives you it's like a pre-test to your actual test. It's like a practice run. So if it's your first time, I would highly recommend the international phase because you get that extra time. It helps you have more conversations with your lawyers. It helps you to just school yourself on what are you going to do? How are you going to grow the business more? Like there's all of this other like extra stuff that you can actually like put in, and it's not quite hand waving, but it is more, you're going to go through the wheel of asset management a few more times after you end up with your, we're going to over to that because it's now relevant. So you're going to run over to your wheel of asset management here, and you're working on your community development contracts and structural changes for your business to be able to incorporate the actual document of a patent. That's kind of what this is. You're making a development contract with the actual like nation itself. You're making a development contract with the United States. You're making a development contract with Canada, the company Canada or the company United States. Like you would make a contract with Coke. That's why this takes so long, because you're acting, your business is now attempting to act at a national level. And that's great, but it is a huge learning curve. Your plan for action is actually this development contract, and that's what gets spelled out. So she's all good and informed. What do you do after the fact? We're going to jump back to the other one. And where is this? Okay. So right at the end of your 30 months, and here's the thing, it's like if you're confident in the international, what the opinion of the international thing is for, you can, shorten the extra 18 months to just like, if you needed the extra, maybe you only needed 16 months, or maybe you needed, you can shorten that down. It's not 2.5 years long. You can shorten that down into a year and a chunk of change. But what happens at the national phase? So the national phase is basically where that's in the sort of under me in the video screen. So when you file it, it goes up online. It's a publication, but it's not the publication. It's not the officiated publication. You're still in this constant editing process. And what the patent is, patent's kind of like the final draft. You're not going back to really change it. It's done. It's complete. Everybody's, your government, your lawyer, and whoever else is involved, have all kind of agreed that, okay, we can float a trial victory on what we're saying here. So you and that's sort of where that's so back on the bottom there's this national phase. A national phase is basically it's part of the Paris thing that I was talking about earlier, where you take your initial patent application and then you transfer it to the nation you want to defend it in. So in the case of the United States, that's going from the you just sort of you file twice with the USPTO, saying like, yeah. So that once you've entered into the national phase, and this is what is considered like patenting in its more commonly understood term. Everything else is like homework and buying time and all this extra stuff. But when you enter the national phase, now the national sort of public defender patent, Albert Einstein there is going to be looking at your patent and following his metrics and his laws to determine if this invention is indeed, in fact, an invention. And it doesn't matter what you think. And that's the part that sucks. Okay. It doesn't matter what you think at this point. You've sort of like sent your kid off to school and now you're waiting for like the teacher's first report card kind of thing. So there's a couple of rounds of conversation between you, your lawyer, and the other, the patent office, on how this piece of law is going to be finalized. Yeah, finalize. I like the word finalize. Finalize is a better word here. So basically, the patent. At this point, it's the examination. So some countries have a separate examination fee, so you can apply it to the national thing, but you can still buy extra time by not asking for an examination. But if it's never examined, it never goes to become a patent. So you just always have to just buy when you apply to the national, apply for the examination because you went PCT. Because if you went PCT, then it already kind of did that for you. So you do have to do a bit of your additional homework with your lawyer, and your lawyer is going to be able to suss all of this out for you and give you the clearest picture because they're the professional on this. But anyway, the examination period is when the national examiner looks at your claims section and they read everything, but then they get stuck at the claims section because what they're comparing is they're starting to determine the apples and oranges of two different documents. So it's like in my example, we submitted to the USPTO, and the USPTO came back to us and said, no, these other guys did exactly what you said. And we're like, well, the initial thing is like, no. And you with your lawyer now have an opportunity to sort of say, here's why you're wrong, and send that out. And then the patent officer reads it and then tells us, no, you're wrong again because of these other reasons. And it becomes this back and forth until we just finally say, okay, this is enough. There's a final decision whether or not they're going to go ahead with it or they're not going to head with it, or they're going to be able to sort of open that book and look inside and, really, it's called a prosecution. It just means they're doing their diligence to make sure that this is indeed an inventive, and you have to show the inventive step, or talk about the thing that makes it unique. And it's sort of like, just because it's your brand doesn't mean shit. First of all, this is the part that I kind of had to wrap my head around. It's not that the brand doesn't mean shit. It's just more of like, here's my pen. A pen is a pen, but also here is another pen. And then also here's a highlighter. I have three classes of writing utensils. This is a clicky pen. This is a clicky pen. This is not a clicky pen. And this is a highlighter. right? So what's the inventive step between this and this and this and this and this? And you know, the highlighter uses a different tip technology. You know, the highlighter is a different tip than the ballpoint pen. But these are just ink cartridges filled with an applicator tip, right? But my clicky pen is also a ballpoint pen, and it's all the same, but I added in this clicky technology that acts as a cap. So you can kind of start to see how all of these, like, okay, well, maybe if I had, those like multi-clicky pens where it's like you click it and there's like all the rainbows inside the rainbow pen ones that have like 6 or 7 different ink colors in it. You start getting into these legal frameworks that differentiate and delineate the type of invention. So these 3 pens have 3 things in common with them, but that just means that these 3 different types of writing utensils will be used against your argument, your patent, as to your invention. So it's like if you had one of those mechanical pencils, the mechanical pencil functions, it has something similar with this ballpoint pen, with the clicky ballpoint pen. But it's a different type of, the fact that you're writing with graphite as to a ballpoint pen is different. It's the invention there is I click multiple times and the lead comes out. That's the inventive part over this clicky pen, because they both click. And when you open them up, the ballpoint pen has a different, it has a different pen and spring structure, as opposed to, oops, I think I might have just broke that. It has a different structure as, yeah, I think I might have actually broke that. Oh, fucker. Yeah, that broke. The part that screws in got stuck, and then just like the plastic sheared. Oh, that shit. Okay, anyway. That's the thing there, where it's like the mechanisms are different. So there's an invention between the mechanical pencil and the clicky pen, and there's that's actually what you're showing in the claim section, that my invention has these features and the other person's invention doesn't have feature XYZ. We put feature XYZ in our invention, and that's what made it the invention. But that has to be spelled out in English, and if it's not clear enough, or if it's phrased awkwardly, or if it's then this is what the lawyer is going to help you overcome, is these types of language barriers. But that's the lawyer's job, is to make it at least understandable from one lawyer to the other. Particularly if you haven't really picked that up. Because really, no inventor ever goes to law. Yeah, no inventor ever really goes to law school until almost after the fact. So basically, you go back and forth with your argument of why your invention is your invention, and then at some point the patent office basically says yes or no, or they issue a final action. So if you're just arguing for the sake of like arguing, they're just going to shut you down and say, no, you're going to start paying me because you're now starting to waste my time. So you can pay the extra fee, and there's like, and in this timeline thing, there are extensions branching out all over the place. There are many different ways to buy time. There are many different ways to assert your standpoint. There are many different ways. Like it's incredibly flexible because it's handling like all known inventions, not just like car inventions. It's handling like every possible invention ever recorded ever. The whole patent system, and that's patenting, but it really scopes it down into your individual niche and then starts comparing your invention against different subsets of your invention. So if you invented a clicky highlighter, right? If you had a clicky highlighter, you might not get the invention because you're using the same clicky mechanism as the clicky pen or the clicky or the mechanical pencil. But if you manage to make your ink reservoir different to be able to accommodate the clicking mechanism, but still remain this type of tip, you might get it. You might get an inventor patent there. So it boils into the language. My specific example is we filed. And then we came back with something that was like really close to what we were trying to show. What we're trying to show is the development of the technology, because people have to still be, the patent itself is still a teaching tool, like an academic publication is, or a trade manual or something like that. So it's more of trying to teach other people, like, no, like when the cat's out of the bag kind of thing. You're actually able to build and make and maintain, for whatever intensive purposes you have, for the good of all kind of thing. But in my specific example, we've had we submitted to the National Patent Office. They came back with a couple of examples, and then we went back to them and said, no, these examples aren't appropriate for reasons XYZ. And then the patent office came back to us, and we did this about twice until the patent said this is the final notice. So I was like, okay, well, now we have to it's not the official final notice, but now we have to actually make them understand. It's like, no, we're making this way. They aren't. If you follow their instructions, you can't make our thing. But if you follow our instructions, you can make our thing and you can make their thing. So there's that. You qualify the inventive step by going. I just want to draw this out, but it's like a Venn diagram, but it's not a Venn diagram, because don't use highlighter, haha. But it's like us, our invention. It's like you can't not take it personally, but that's what the lawyers are to prevent. So it's like, here's our thing, and then here's their thing. So it's like, okay. So their invention can take you this much farther away, but our invention takes you this extra mile that they can't do. And so that's what we're trying, and that's what we're rephrasing our claim sections to go. So this is really what I would really say that this is really what you need a lawyer for, because it's more of ensuring that you are able to articulate what the hell it is that you're saying to the other person. And this is where communication is key here, because it's like, if you don't communicate what you actually did, it falls flat. And that's why you have pictures, and that's why you have those other that's why you have a background information section. That's why you have the pictures. That's why you have the picture descriptions. That's why you have the summary of invention. That's why you have the other 10 parts of the patent to back up and enforce your claim sections, to buy you that extra time with the patent office saying, no, we're not describing this properly, so we're going to have to describe it proper. We're going to have to change a couple of things to make sure that this goes through, because they agreed with our other sections. They're just not agreeing with this final one. So it does kind of get into this like nitpicky stuff, and you have to have the patience for that. This isn't just like, here's my it's not the TV show of your Shark Tank kind of stuff where it's like, you just sit down, the TV episode of Shark Tank is representative of, sometimes up to, multiple decades worth of work. And it could be, 15, 100 employees, 200 employees kind of thing. It could mean, But that's what you don't see anything. You just see the little corner on the picture screen, and you collapse. Yeah, basically, I kind of don't like those. Like, I like those shows, but I kind of don't like those shows. It takes like, here's 50 years worth of 50 people's work, and it collapses it into 15 minutes and it's disposable. Next please. That's sort of extremely disingenuous, and it's superficial. Mind you, it's a 15-minute national advertisement for the person who did get on that show. Congratulations to them. Huzzah. That's, that's what it's worth. But it does kind of shortchange the amount of work that sort of goes in, even the deals themselves. They're threaded out for time and all that. So it is kind of like, show me the hour-long after special where they all sit down with their contract lawyers and actually hammer out a check. That's just sort of the 2 cents there. But patent, it's not a terrible thing, but you do have to do your homework going into it, and there are resources available that will help you. So we used it's an IRAP program. It's available in Canada. It's an industrial research assistance program app for small businesses. There's the professional services program and the small, I don't know, it was the FSP. It was a small fund. Professional. One was for professional services, and the other one was for expanding the project for the professional services. So they were used like A, B, and C, and then there was a third one after that we sort of said they'll pay half. The government basically says on the third one, okay, we're going to pay half because we paid up the upfront on that one, and that's totally fair too. So it's like, okay, they paid they paid the gas to get the train going, and then they said, okay, well then you can get it up and running. How you kind of approach this with your company, how the patent fit. The patent is something the company owns. A lot of people hear it along the lines of, this is the get rich quick scheme that I really don't like most of the time, because it is sort of like it's just basically taking you for a ride. There's nothing there. But where you really kind of want to go with that is basically you're patenting it to protect your company. You're patenting it to protect your company's value, not to sell it off and license it. It's like the licensing comes after the fact when it's there and you need to expand your business services. So that's kind of what it kind of can be used for when you get into like the money. People only care about the money deals instead of the like, well, what the fuck did you go through this whole fucking process for no reason? You went through this whole process to protect the actual business itself. nobody, you know, will look at fidget spinners. Fidget spinners are easy and they kind of flooded the market. They got on a hype train and just kind of went off to like wherever, right? But the patent for the fidget spinners protects the manufacturers of the place and ensures that the person who invented it gets their fair share, and the company that does it gets their, is able to be a company. It ensures that you can put food on your table, kind of thing. And that goes into patent strategy. So it's like, did you just do all of this work? You can shortchange it and just go right into the national. Forget about your like patent pending stuff and just go right, provide your application phase and then go right into your national phase and have this thing completely done in like, two. I was gonna say 2 months, but I'm prone to grossly exaggerating. But you get the idea. That's the point. We get the idea. Is there anything on the wheel? Yeah, going back to the wheel, because the wheel still has some good relevant stuff for this. So on the wheel, your development contracts and your advertisement. So when you get your patent pending status, that opens to be able to advertise what this thing is. The lawyer's going to really instruct you on like what you can and can't do, but you get your patent pending status, and then you can begin to really get the credit for your product through different types of investors, and attracting investors, because now you're saying to a financial investor or a manufacturing investor, or just somebody who gives a shit about your product, you're helping to protect them as they sort of like, if they want to manufacture your stuff, they know that their investments in the molds, the injection mold and the tooling and stuff like that isn't going to be screwed over by somebody else. So they can start building stuff with you to be able to ensure this. If you want to sell in somebody else in like a larger market, this is something help ensure that your development into that market is going to be valuable. In the sense that, 4 other companies aren't going to immediately outcompete you because you just entered the market with something, basically unprotected. So that's sort of the plastic world of it. But at the same time, it's still a tool that you're going to have to learn how to use on your own. Most of the time, it's used to assure investors against competition. It helps you create that monopoly. But the monopoly is found in the infrastructure that you build and create to become the larger business. Because when this patent thing expires, when she's done with it, basically, you can be the big guy at that point. So you could get 10 to 20 years. 10 to 20 years is a really long time devoted to, pen manufacture. How much technology can you throw into pen manufacture in 10 years? Quite a bit when it's you kind of in a walled garden, when it's kind of protected. Plus, of course, you get different. Once it's issued, you really get to think outside the box, and even in the patent pending phases, you can really start working your advertisements to grow different parts or segments of that business, where it's like, okay, your main product, you're sheltering your main product inside the pyramid kind of thing. If you go to the American dollar bill, it's like you're enshrining your product, and now you're free to sort of talk. Now you're free to talk about it. Now that it's patent pending, or even patented. Even if it's patented, you can start opening up that little that goodie basket and say, okay, well, I want that company to do my shipping and distribution. I want that company to handle this type of marketing. I want this to do that, and that's the freedom you're purchasing with the patent. It's like you're able to do that. Like you're still able to do that, but you're doing that with the national backing that says, yes, you are the source point of this technology. Congratulations, you get to pick and choose. How you are skilled in the art of business after that, well, that's you. That's that's your that's your toast to good health. That's your retirement plan, basically. How do you okay, congratulations, we gave you the patent. Now what are you going to do with it? And that's usually that's when you actually go to work, because you have to. It's not the patent itself that's valuable. It is the rest of the nation that it is representing that is valuable. So it's like, how do you grow this business to incorporate, these other people's, these other applications, these other manufacturers, these other, because you might have to have different supply lines. You might just have to have an assembly line to it. You have to have, you start getting like, what does the factory look like that's going to make this product? So congratulations, you're the only one who can manufacture it, and you're the only person who can say, company S manufactures it. Well, company S manufactures it, but what happens when company Q starts manufacturing it also? The patent stops company Q from doing it, and it protects your buddy in company S. And that's the whole idea of the monopoly. You do get to play favorites. You get to cherry pick. Cherry picking is cherry picking. You get to cherry pickers. And that's the whole point of patenting. You're allowed to protect your own little industry for the betterment of yourself, your family, your friends, your region, your city. It brings in it might not bring in money, but it protects the money that does get invested. And that's it. That's it for tonight. It's been the Power Hour. We've been doing we're doing patents tonight, and it's an education in and of itself, and I hope you enjoyed. A bientôt. Ciao. This Power Hour has been sponsored by Innovative Potential.